Hello, I'm Kathleen Benoit, co-host of Living Well in Montana with my host partner, Corby Skinner. Living Well in Montana is a program of living independently for today and tomorrow. It's a nonprofit organization headquartered in Billings and devoting its energies and services to Montanans living with disabilities. In the state of Montana, of eastern Montana, there are 18 counties that LIFTT, Living Independently in Montana, serves. Today, our guest is Dr. Paula McMahon. She is assistant professor with the rehabilitation program at MSUB. We are so excited to talk to you because you are just a specialist on Americans with Disabilities Act.
I would like to consider that I am, yes, thank you.
Welcome.
And I'd like to say you're also a board member at LIFTT.
That's
so
right.
You're wearing two hats today.
I am, yes.
What we are going to do, and I think this is really interesting and important, we actually have two programs today, and we're going to first talk about the history of ADA, and we'll go through when that started, how it's evolved and changed, and then we will have another program that talks about the various aspects of ADA, the various components of it that make up the program. So I think we're going to start today with the history. When I looked at your slides, Paula, that you had sent me, I was shocked to see how relatively recent the whole ADA program is.
That is correct. Although one thing that's wonderful that we can note today is that we're celebrating the 30th anniversary of the Americans with Disabilities Act and all that that brings.
So let's talk about the beginning. How did it all start?
Okay, so I'm going to talk a little bit going back to the independent living movement, because you really can't consider the history of the Americans with Disabilities Act without looking at the independent living movement. Ed Roberts in California was enrolled as a student, and he wasn't able to access the same opportunities and as other students in a higher education environment. And he really wanted to be able to make the same decisions that his peers were making. Just like being able to determine when he went to bed, when he got up in the morning, you know, what classes he got to go to, and other opportunities. And so he created the first Center for Independent Living, but he also engaged in a grassroots movement that allowed people with disabilities to recognize themselves as a community and realize that they were going to be able to initiate and create opportunities for change.
I'm interested, was he a vet?
Not that I'm aware of. I do not know.
I just wondered in terms of the timing of that. There were so many people returning from Vietnam that...
So interestingly enough, that's a good question. Not specifically with the Americans with Disabilities Act, but if you look at the movement of rehabilitation in general and vocational rehabilitation specifically, every time there's been a big jump forward in terms of vocational rehabilitation, how it's serviced, how it's funded, it has often been associated with returning veterans and creating opportunities for them to be able to reintegrate into the workplace effectively, which kind of ties into the Americans with Disabilities Act in the sense that many of the employment protections and advocacy opportunities that that program created allowed people to be able to advocate for effectively integrated workplaces that were accessible.
Was there pushback from different parties or groups when this first became a project?
So I will get into that a little bit as we progress through the presentation, but yes, there was.
Okay. Primarily
from businesses, and then if you look at the history, looking at schools and how they fundamentally had to change their programming, which the 504 Act was the inspiration for the ADA, those things kind of tie into each other.
Thank you. I'll wait for the full story.
So how did the Living Independent movement move into the next steps?
Well, what I would say is it galvanized a lot of the disability community, because until the decision was made in California and the creation of the new Independent Living Center occurred, they'd been somewhat disparate. And I think being able to look at disabilities and have it fall under one umbrella, rather than parsing out disability as each individual disability-related issue, they started to see themselves as a community that wasn't defined by their disability, but instead was galvanized by their advocacy.
Mm-hmm. And I think that's important to know when we're talking about LIFTT, living independently for today and tomorrow. A lot of people assume that it is just about people with physical handicaps, and that's not the case. It's really for people with any kind of disability.
Yeah, so LIFTT provides a comprehensive set of services, particularly advocacy opportunities for individuals with disabilities, kind of across the spectrum, and they also have transition services for students between the ages of 14 and 24. And so students who are looking to transition from middle school upwards will be able to access services. And any student who has an IEP or is receiving services for an identified disability should be able to work with LIFTT to kind of work on those transition opportunities.
Mm-hmm.
An IEP is?
An individual education plan.
Thank you. Thank you.
Right.
Very important for the success of those transitions, too,
Yeah.
from what I understand.
Yes.
So let's get back to the history.
Yes.
Do you want to take
Okay.
us to the next step?
So I will take you to the next step, which is, so it's important to kind of look back at the laws that preface the Americans with Disabilities Act, because they often really had created the language and started to get people considering how to most effectively navigate creating a law that would provide more comprehensive supports for people. So Section 504 of the Rehabilitation Act created the defining language, which is that no qualified individual with a disability in the United States shall be excluded from, denied the benefits of, or be subjected to discrimination under any program or activity that receives federal financial assistance. And what that meant was it created a more inclusive umbrella for disability-related issues, but also gave people legal recourse, so that if they experienced discrimination, they were able to then to identify an opportunity to push back. But there were some challenges within this that we'll kind of get into a little bit, because the enforcement agency for Section 504, when it came about, was somewhat of a reluctant enforcer. And so that again kind of goes back to that grassroots movement. You really can't consider the Americans with Disabilities Act history without considering the grassroots advocacy groups across the United States of America who are engaged in really making things happen.
So it's a nice thing to say 504, here's the law, but then how does that manifest itself? How is it regulated? How is, so there may be pushback from
so
businesses?
often it's case law that ends up deciding how a law is interpreted. You'll find that with the Americans with Disabilities Act. That's also true with Section 504, particularly in its early stages. There was often what would happen is there would be suits filed that would then kind of redefine the law, sometimes better, sometimes poorly, depending on the circuit court it was going through. And then that would also kind of re-engage that grassroots effort.
Well, that was my question, is with the grassroots, was it an explosion of passion and volunteerism, or was it slow to get moving?
I think initially it was slow to get moving, but I think that it gained momentum, frankly. And then, yeah, once it started gaining momentum, and there were advocates going across the states doing presentations and education, and we'll talk a little bit about Discrimination Diaries later in the presentation. So there was a lot of opportunities for both parents of students with disabilities and individuals with disabilities and their extended family members and friends to kind of galvanize that support.
And 504 guaranteed what specifically?
So what the Section 504 did is it created effective discrimination language. It currently is more utilized in a higher education environment. And what it does is afford students access and opportunity educationally. It's not necessarily as comprehensive as an individual education plan, but a 504 plan is another thing you'll see in a higher education environment. And often students who have medical or health related issues will have a 504 plan that will help kind of identify strategies for them to be able to ameliorate those medical health issues in that educational environment. The Rehabilitation Act is also typically the predominant law for people who are in federal agencies. So the Americans with Disabilities Act applies everywhere else.
Right.
But if you're a federal employee, you would look at the Rehab Act to determine how to be most effectively accommodated.
Yeah, that's interesting because we have talked with other LIFTT employees that have specifically talked about transitioning for young people in grade school and specific plans that help them. But really, this is a lot about people, teenagers and young adults.
So there's an interplay between the Americans with Disabilities Act, Section 504, and if the individuals, so students who are receiving education and have an IEP, and so you'll find that different laws kind of meet different standards. And so say, for example, if a student was looking to get access into a building, and the building was inaccessible, or they had a classroom that was inaccessible, the Americans with Disabilities Act would more readily apply in those circumstances. So for want of a better way of putting it, I'd say that there's an interplay within all of these.
We think of, at least I think of, when we're talking about ADA, it has a lot to do with physical access. I mean, most people, when they think of ADA, we need to have wheelchair access, or we need to have bathrooms for ADA. I don't know that people are as aware of those other rights that are a component of that program.
Well, I think sometimes it's not understood that there's a lot of employment rights associated with it, but also on the different titles of the ADA mean different things. And so typically you'll find that if you're in a K through 12 situation, Section 504 would apply. But then once you transition into higher education, Section 504 and the Americans with Disabilities Act and the language around programmatic access is going to be more utilized in higher education environments. And so there's a set of different standards. And so, for example, if a student has an individual education plan in a K through 12 environment, it tends to look at things on a much more granular level. There's a lot of evaluations that are involved in that process. So if a student moves into a higher education environment, such as the place that I work, really what they're looking at is how can we afford accommodations so that they can utilize programmatic access.
You sound so passionate about this, and how long have you been advocating?
So I actually worked as a disability rights advocate for 5 years in Virginia at the Disability Rights Agency. It was then called the Virginia Office for Protection and Advocacy, and it's now the Disability Law Center of Virginia. And then I actually worked as an independent living counselor for 5 years. I'm showing my age here, and
well, you don't look it.
and I worked as a disability rights advocate for 5 years, and then I was an Americans with Disabilities Act coordinator.
And then you made it a career. I mean, you literally have. You're still advocating and teaching and educating.
In essence, yeah, and I think that's part of the reason why I'm on the board at LIFTT, is it's something that I'm passionate about, and I think it's important to work with communities to identify those opportunities.
I know on every application, whether you're hiring somebody or applying for a job, the term EEO shows up, Equal
Employment Opportunity. Yeah.
Can you talk a little bit about that and when that actually historically came into play?
I don't actually know, so I did not put the information in about the EEOC and when it came about specifically, but the EEOC does provide comprehensive access to people, and so generally if you want to file a disability rights discrimination complaint in an employment in a place of employment, you might utilize your local state agency, and then you might also go to the EEOC to navigate that circumstance and say, you know, here's what I'm experiencing. And typically the EOC will work in collaboration with this local state agency to identify how to who's going to take the case and how that's going to progress.
So we're talking about education, we're talking about employment, but also housing. The Fair Housing Act.
Yeah, and I have a little bit of information about that in my slides if we want to progress forward with that.
Right.
So I'm going to go back a little bit, if that's okay, to Section 504. Section 504 recognized that while there's major physical and mental variations and different disabilities, that people with disabilities as a group, that if you identified, I have a disability, irregardless of the circumstance, it could be that you have a mental health concern, you're navigating depression, you have an issue with, mobility, you have an issue with something with regards to your daily functions that could impact you, that all of these people, once they self-identified, were experiencing discrimination in a variety of different capacities, in education, in employment, but also in fundamentally accessing the day-to-day things that we all like to enjoy. And so Department of Health, Education and Welfare was given the job of enforcing Section 504. And Section 504 basically, they were a reluctant enforcer at this juncture when it first came out, and so they really weren't enforcing the guidelines, and so it took the disability rights movement to really start doing sit-ins in offices across the country, and you'll see a picture of people who are doing that, and they basically sat in all of their buildings protesting and saying, we need you to enforce this regulation, and they did letter writing, parents were involved, people went to hearings, and on May the 4th, 1977, and I have to check this just to make sure I get the date right, the 504 regulations were issued, and a lot of the language from Section 504 determined the language that was going to be placed into the Americans with Disabilities Act. And the other thing that's worth considering, like I said, this is all kind of getting people engaged in the process and getting them motivated to kind of move forward. And they had seen the progress that other advocacy organizations had, and so they wanted to be able to create similar traction for the disability community. And so in 1988, the civil rights community amended the Fair Housing Act. And that basically improved their enforcement mechanisms, and it created anti-discrimination provisions for people with disabilities in housing for the first time. And a lot of allegiances were formed in this particular circumstance. So like, say, for example, parents may have been a very different group to individuals who were like typically served through independent living centers who are adults, but they all started to become kind of under one umbrella of advocacy, recognizing that there needed to be this kind of grassroots collaboration to start seeing things move forward. And it was really important for people to understand how to engage in that.
And it must have been almost exhausting to have to keep all of that excitement and support going without being discouraged or giving up or saying it's not going to happen. 30 years ago,
yeah,
and look how it's grown.
Oh yeah, and there was some poor case law that had occurred as a consequence of decisions that were made through Section 504, and that kept galvanizing the disability community in engaging in the process and in pushing it forward, because they recognized that this law needed to be effectively enforced. And as I indicated earlier, when you have a poor legal decision that's made, you need to be able to then kind of regroup and say, okay, that's not good enough. We need to still be able to create opportunities and access. I mean, we all want the same thing fundamentally. We all want to be able to live independently, have our relationships, go out and go see a band, go do something fun, and have employment.
And you had the ACLU and you had other organizations in your network by then, where it was growing to a real movement.
Yeah, absolutely.
And I think when the general public thinks of the Fair Housing Act, they think it's a racial issue rather than one that encompasses also disability.
And initially that was true. And then once they created the new regulatory language with the new anti-discrimination provisions, it really galvanized creating opportunities for people with rentals, and then also more recently people being able to have emotional support animals, which is different to a service animal. So a service animal, the Americans with Disabilities Act has very specific language about what makes a service animal, whereas the Fair Housing Act allows for emotional support animals and has a broader allowance for what animals can be considered for that. So, okay, I'm gonna talk a little bit about some of the poor legal decisions. I'm jumping ahead here. I hope that's okay.
Please.
And so there was the Consolidated Rail Corporation versus Darone in 1984. And this was one of the poor legal decisions that kind of, again, kept them galvanized and motivated. They employed a locomotive engineer. They determined that he was disabled, but they didn't find him unfit for employment, which was critical to the legal decision-making process. And they basically argued that the case should be dismissed because they were arguing that he couldn't bring forward a suit under Section 504. And what was really interesting about this is there was a grassroots. They recognized this case was going to be critical. Prior to this, there had been some bad legal decision making. The disability community were like, okay, this case is going to be critical. Let's engage in this. Let's call in all the forces. And so they had the Disability Rights Education and Defense Fund. They filed an amicus brief on behalf of 63 national, state, and local organizations dedicated to securing the civil rights of people with disabilities. And they really engaged in an education campaign and in publicity to try and make sure that people understood what was at stake. And the court found that employment discrimination was in fact prohibited by Section 504 because they were arguing that semantics on terms of language and the regulations issued in 1977 by the Health, Education and Welfare were entitled to defense by the courts. And this was really huge for people with disabilities because it really did then entrench language that afforded them some additional protections when identifying themselves as having a disability in a place of work. And it's the regulations that were identified and created, not created, but were elevated by the court in this case, became the language that formed the basis of the ADA.
So really the pivotal moment in terms of, I was just reading in Montana history, the history of women suffragettes. There are moments in time where everybody realizes this is something that's going to make the major change. And certainly that's the case. Paula, we have about 5.5 minutes left. And we still have some history to go.
So I'm going to do a quick synopsis of that,
yes,
okay?
Thank you.
So I'm going to talk a little bit about the Discrimination Diaries, which was basically looking at to educate people about the need for the Americans with Disabilities Act. People were encouraged to document their daily experiences of discrimination or lack of access. And these diaries educated people about the barriers that were experienced by people with disabilities. And Justin Dart, who was chair of the Congressional Task Force on the Rights and Empowerment of People with Disabilities, traveled the country holding public hearings that were often observed by members of the public. And they basically, people talked about these experiences that they were having, and it really brought home to people why this was so important. And it was basically an opportunity to bear witness to people's experiences. And so then a hearing was held between the Senate Subcommittee on Disability Policy and the House Subcommittee on Select Education, and witnesses from all backgrounds came forth and testified on behalf of their daily experiences and why it was really important and critical for the Americans with Disabilities Act to become law. And so there was a lot of public pressure being put on representatives at that time, and there was a lot of publicity associated with it, and then there was a presidential race that was going to occur at that juncture.
I think it's always important to realize how human stories, personal stories, are the ones that, those diaries, those witnesses, really made the changes.
Yes.
They did make a significant change. And so on May 9th, 1989, Senators Harkin and Durenberger and Representatives Coelho and Fish jointly introduced a new ADA to the 101st Congress. And there were multiple hearings. There was a lot of challenges. They went through 4 different committees before they started to really have the language defined. And there was a huge coalition that came forward of different organizations, the Consortium of Citizens with Disabilities, which included multiple disability rights organizations all across the United States of America. And stories like these are really, for me, what makes America great, is when you hear these stories of people unifying together to kind of make a significant change and move things forward. And so, just so that we can get to it, July the 26th, 1990 was the signing at the White House. And it was bipartisan signing, so it had bipartisan support from both Democrats and Republicans, which was wonderful. And basically George Bush Sr. signed the ADA into law at that juncture, which was really significant for the disability community.
30 years ago. So again, we're celebrating that anniversary.
And I wish we had time to say, what do you predict for the next 30 years? What's the next step?
But there continually are changes and adjustments.
Yes.
There are. So there was bad case law that interpreted and narrowed down the definition of disability not right after, but in the time after the law was signed. And so Congress kind of was like, no, this was not our intent in signing this law. We wanted it to be expansive. We wanted to offer opportunities for people with disabilities. And so in 2008, they signed the Americans with Disabilities Amendment Act. Because they viewed the previous legal decisions that had been made as not really representing the intent of the law. And so they basically then broadened the definition of disability, amended the list of activities deemed to constitute major life activities, and redefined the meaning of the term substantially limits, and amended the regarded as prong. And what this meant is they were saying, we intend for the judiciary to look at the Americans with Disabilities Act as a method of protecting people with disabilities effectively. Do not narrow down your interpretation of this law to protect businesses or employers or that pushback that you were talking about with regards to what the intent was. What our objectives are is to really look at making sure that we're creating opportunity for access.
And to continue.
Absolutely.
Paula, it's a pleasure speaking with you, and you have so much information that you can share with us. This is part 1 of a 2-part series. We're going to be talking more about the consequences and what does the Americans with Disabilities Act mean for people.
So we've talked a little bit about the history of it, the evolution. So I think in our next program, we're going to dig a little deeper.
Yes.
Great.
And talk about the 5 various titles which are the components of the ADA.
Correct.
So, Paula, thank you for being with us. And you are continuing to teach this fall?
I am, that's correct. So I've been now working at MSUB for the best part of 3 years.
We appreciate your taking the time to meet with us, and we look forward to part 2. I'm Kathleen Benoit, my business partner, Corby Skinner. We are co-hosts of Living Well in Montana, which is a program of living independently for today and tomorrow, LIFTT. We'll see you soon.